we did not really have a choice. I did not think that inaction was an option here, because this was obviously the most brazen, the most obvious evidenced case of aggression that we had seen. And had we been inactive on this, I think it would have been a huge mistake.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
Well, it seems like a really long time since we covered something that was taking up an amazing amount of time a year or two ago. We were discussing the idea of a special tribunal to judge Russia's alleged aggression against Ukraine.
Yeah, remember we were kind of giddy with the possibilities, and could we really have this international lawyer's holy grail, an actual tribunal for the prosecution of the crime of aggression? And we covered a lot of discussion because it was argued over so long and hard by a number of lawyers, both inside Ukraine and outside.
And really, there was quite a number of conditions that it needed to satisfy. I described it as a 3-card magic trick. You needed a tribunal that was going to be international enough to be able to potentially put the Russian president, Vladimir Putin, actually in the dock, because he's a member of the Troika, which is the 3 individuals, head of government, head of state, and Minister of Foreign Affairs, who could only potentially be prosecuted by an international court and not by a national court. But it also needed to be Ukrainian enough to satisfy their needs and for them to have some degree of ownership. And it also needed to be not quite too innovative and not quite too wide-ranging, because we already have the International Criminal Court, and that already has the crime of aggression on its books. And you needed to make sure that what they were planning to do was also protected in some way.
So in the last few months, we know that lots of experts came together to discuss the issues. And finally, in May, they announced that a court had been born. We haven't seen the statute yet, but what we all understand from the briefings is that this will be set up with the Council of Europe. There will be immunity for the Troika while they're in function, but there will also be in absentia trials possible, which was a big sticking point. It will be rooted in the jurisdiction of Ukraine, and countries have to sign on to it.
Now, to get into some more of the details, we've got a couple of guests with us. First of all, we have Gabija Grigaitė-Daugirdė, who's now Deputy Foreign Minister of Lithuania. Hello, Gabija.
Hello.
And we have Christian Wenaweser, Liechtenstein's ambassador to the United Nations.
Hi, good to be here.
Now, you've both been at the heart of these discussions. You've both been on the podcast before to discuss issues around aggression, the crime of aggression, and how to prosecute it. So if we kick off with you, Gabija, I mean, I kept on coming across you when you coming back from all these different meetings. Did you count how many there were? Did you count the number of hours that you put into it? Did it surprise you how long this process was taking?
I think, Janet, when you have important mission or a crucial mandate to be, you usually do not count how many hours and efforts you put into it. What I have possibility to count is the core group meetings that we had. We had 14 of them, and it is interesting because, you know, when usually you have a notebook to take notes, when you look them through, you know, on the position of states, how different events had influence on the position these states had. So it is really, you know, I think amazing that we finally have this achievement in Council of Europe. During all these years, experts managed to come, you know, to have a compromise that we have today on the table. And as you perfectly know, on the 14th of May this year, in the Council of Europe, they received this formal letter from Ukraine. And now there is possibility, I mean, to have this formal legal process being opened, and Council of Europe has this clear input to start this process now. And I think what is very important that Irina Mudra participating from the President Office, participating in this formal opening of the procedure, she used that statement saying that this is the moment where we not only enforce international law, but defended. And I think this is very important what she said, because Kampala amendments for the crime of aggression has generally been viewed, as a sort of breakthrough in international criminal justice. But I always say that in general, adoption of the Rome Statute and establishment of the ICC has to be viewed as a broad, peace project to be. And not only because accountability in general is always a part of the peace process, be it national society, be it international society, but also, I would say that complementarity regime also reinforce, responsibility. But coming back to the crime of aggression already in Rome, it established the legacy of Nuremberg, that, we have a crime of aggression as it was crime against peace in Nuremberg, a crime that safeguards the fundamental highest value of the international community, that is the value of peace. So first of all, we enforce it, and then we defend it, because it cannot stay on the papers for the reasons that we all perfectly know. At this moment, criminal court cannot exercise jurisdiction over crime of aggression against Ukraine, so we have to defend it and establish tribunal.
So, Christian, what about you? Gabija mentioned Kampala. You are the architect, the father of Kampala, and the man who knows all about aggression and how the ICC works. And we'll get back to that whole process. But now to kind of look at what came out of the Ukraine suggestion for the tribunal. What did you make of the whole process? You are a veteran of sitting in at these talks. There was a lot of talk at the beginning of the tribunal about immunity, lifting immunity, and now it came out that there is immunity in this court. What stood out for you from this whole process, and specifically what came out? Ukraine Tribunal's suggestion.
It's a very lengthy process. I did not attend all the meetings myself. I also sensed relatively early on that it would just to an extent be a circular discussion for a while. We felt pretty early on that we had gone through the legal options and it was essentially a political problem that we were facing. And to overcome that took just as long as it did. It also, of course, took the Ukrainian leadership, I think is fair to say, that time to come to the conclusions that they came to, because we always said, we are here to support Ukraine. We are following Ukraine. There are, approaches that we would probably not actively support, because we also have the interest of public international law very high on the agenda. But of course, we will defer to Ukraine and form our final opinion on an outcome that we have. So I think in some ways it was not that surprising that it took so long, because on the matter of immunity that you pointed out, there was just a strong disagreement among those who felt that, aggression being a leadership crime under international law, it would be very difficult to have a tribunal that would not be able to address immunities and still be a credible tribunal. And, that is how we felt. And to some extent, that's still how we feel today. And that was, in a way, the crux of the matter. You have seen the statements from the Ukrainian leadership during that process, always emphasizing very strongly this point. And the outcome in the end is a bit different. It's the outcome that we now have. It's now in the Council of Europe. We are very satisfied that the process is concluded. At some point, we said, look, we have invested a lot of time. It's nice for my excellent legal advisor to be able to go to all the capitals that are in Europe. But at some point, we have to take this to a conclusion, and also because this is a political call to make. And now we are able to move on with, I think a lot of open questions still, but I think we're all happy that we have ticked the box and that this is now in the Council of Europe.
Gabija, you described it as a compromise, and I think Christian's sort of spoken about it being essentially a political decision in the end. I mean, that Ukrainians had to agree to the more general perception of what was possible and what was actually impossible. Can you give us some insight into what you think was actually agreed? What was the compromise? I mean, we've only seen reports on it, and I know, the statute itself hasn't been made public, but what would you like to point out to say these are the essential things that were agreed?
So I think as in every difficult diplomatic discussion, we talk about, certain package deal that was important for Ukraine. and that try to combine, different positions from different states' perspective. So these core, I think, elements, I think definition is a huge victory to have, because there were quite long discussions over the definition of the Rome Statute should be there in the statute, and I think it is very important. And then what you mentioned first, Janet, immunities, of course, because Lithuania, together with Liechtenstein and other countries, we, as Christian mentioned, we were always very vocal about that, applicability of immunities to the leadership crime in general contradicts the idea of a leadership crime. And we have very straightforward case law saying that it can be lifted by international tribunals. Then, of course, basis of jurisdiction, because if we talk about how international one tribunal is and how another one is not, it ties directly with the basis of jurisdiction. I mean, where the jurisdiction for the tribunal comes from. Here we talk about, that the tribunal, the statute of which we have on the table now, the basis for jurisdiction is territorial jurisdiction of Ukraine. Then if we talk about in absentia, the other hotly debated issue in the core group is, of course, how far we can go with the in absentia, or even with immunities, because I think it's already little but still a victory that we will be able, public prosecutor will be able, following the precedent of Tribunal for former Yugoslavia, to have this presentation of evidence even for Troika. I mean, there will be possibility to have this sort of public presentation, to make public formal document containing, the charges and material facts. And I think it is very important, because understanding limitation, understanding all the challenges that tribunal will have inborn, with the statute, such a possibility is already quite an achievement, because we understand that, first of all, this is the crime against all the people of Ukraine. So possibility for them to see and understand that justice finally arrives, even in limited capacity, I think it is very important. So everywhere we have some compromises being made. But I think it is important what Christian has also mentioned, that this development of Ukrainian expectations was also important, because, we cannot have this process going on forever. So we finally had to understand what are policy goals of Ukraine in this process. And then our mission was to try to find the best way, the best compromise that could allow them to achieve the goals.
I know that you both, probably not diplomatically or can speak to this, but to kind of lay out in terms what was agreed, as I have understand it, being briefed by the Council of Europe and by the EU, but not having seen the statute, is that this is going to be something that is set up between Ukraine and the Council of Europe, and countries can sign on. There will be functional immunity for the Troika, and the Troika is the President, the Prime Minister, and the Minister of Foreign Affairs, so they cannot be indicted while they are in office, but the investigation can go up to the point where a prosecutor would present an indictment to the court, who would then say yes or no, and that would not happen in this case, but the prosecutor could present what he wants the judges to decide upon. And it agreed that there could be trials in absentia, which is allowed under Ukrainian law. Now, for me, as an observer, that feels kind of like there was a give and take between we have immunity, but there will be in absentia trials. And another thing that I really noticed, because I follow so much with the ICC, and the ICC also has an arrest warrant out for Vladimir Putin, and we expect that the Aggression Tribunal will also focus on Putin. They basically say the Aggression Tribunal, as I was briefed, was told the ICC will take precedence if they have a suspect in custody. And which the in custody, of course, is a very important thing, because you can have this arrest warrant against Vladimir Putin, but not have him in custody. But that leaves the way open for if even after he is no longer covered by immunity and he steps down as a president, but he hasn't been handed over to the ICC, you could have an aggression trial. I wonder what your thoughts are on this. Am I summarizing it correctly? Am I wildly misunderstanding? Or would you prefer not to comment and be diplomatic about it?
No, I mean, I can comment, to a point, like the process on immunities goes up to a point. I think your summary is accurate as far as possible before the tribunal. We felt, and I think, Gabija and I are like-minded did as well, that having nothing on immunities and addressing immunities in the procedural steps that you have described in a way is a good way to go. We also felt that we could have gone farther and should have gone farther, certainly to a point of an indictment. That was not the outcome. I've certainly described the proceedings accurately as far as outcome on immunities. We also, saw a link between there is a link between this and the in absentia provision. And we felt it would have been, in a way elegant to say, certain steps can only be taken after a person has been arrested. And that option, of course, is no longer available if you do in absentia trials, which is something that Ukraine felt extremely strongly about. And in the end was one of the key provisions for them, where we had a different view than they did, honestly. No secret, I think, about that. But again, we deferred to Ukraine on this. So we didn't feel that an international tribunal, but that opens the whole, question, how international is this tribunal? And we alluded to that in your comments. But we did not feel that the experience in international tribunals within absentia trials is a positive one.
This is a very veiled reference to the Tribunal for Lebanon, which we've also had podcasts on, and we'll link to in the show notes for the real deep dives. Janet, back to you for next question.
Well, I was going to ask Gabija if you wanted to comment Steph's question. I think left hanging there was a bit the idea of who goes first, which tribunal. If Putin's body is in somebody's custody, then who gets him?
So I think if Putin is in The Hague, then it doesn't make a huge difference, which tribunal takes him first. But there is clear rule that if he is in custody, so ICC is the first one, because we know why, because they do not have this in absentia, but the conclusion is very right. So that if he is not in the power, tribunal can have him being sentenced. But I think sometimes I also hear this question about that tribunal. Of course, everybody of us wanted to see Putin in this tribunal. But I think what is important that with the establishment of this tribunal, in general, we prove that being head of state does not offer you this total carte blanche, for impunity. But finally, we prove that, despite the fact that tribunal will have to wait for Troika, it will be able to do many, many good things, because first of all, we talk about the evidence, the case building that it will already be able to do. And it proves, that overall the tribunal will stand ready and will be able to prosecute persons when they are not in power anymore. So I think, yes, for us, the ones that were the most strongest defenders of international law, because we thought that crime of aggression in general, it is important to protect the victim instead of the aggressor, because we violate fundamental international law rules. But, we have the statute that we have. But I think that it is a very important achievement because this is first tribunal after Nuremberg that actually will prosecute people that have still the biggest responsibility for the crime of aggression against Ukraine.
I'm sure Steph is going to come back on some of the details, but just before she does, I want to go slightly off script and ask you, Christian, when you went into this, as the person who's been, in my mind, most associated with trying to get states to sign up to and recognize the issue of the crime of aggression, and you've worked on this for so many years. When you went into this process, did you think that this was going to be a much bigger, was this going to be the tribunal for you for, that you'd be able to say, yes, I've got the cherry on the cake, I've got the tribunal I've always wanted? And did you end up in the end saying, okay, ticked another box, but I've still got to kind of push the boulder up the hill? How do you feel?
No, it's a good question. We thought about this very early in my team, and I did not jump on this because I did not really believe very strongly that we would be politically able to get the ideal outcome. So I hesitated a bit in the beginning, but then, we in a way initiated the process. We did the first meeting, the first convening on this in June 2022 together with Latvia in New York. And we started the conversation with Ukraine early on, simply because I felt like that we did not really have a choice. I did not think that inaction was an option here, because this was obviously, the most brazen, the most obvious, the most easily evidenced case of aggression that we had seen. And had we been inactive on this, I think it would have been a huge mistake. So, I really don't have regrets that we have the outcome that we have, and that is not the ideal outcome. Is, it is a political compromise, and this is what we do as diplomats. So we are also not at the end of a process, and I think that's extremely important. So we will certainly emphasize the positives, and the positives are what Gabija has said. It's extremely important to have a tribunal that deals with aggression. And I think it will put this very differently on the agenda and make it much more visible. And that is a huge, huge value added in and of itself. And I'm very satisfied that we were able to base the jurisdiction of this tribunal on the internationally agreed definition that is in the Rome Statute. And we had to fight really hard for this. It was really not a given that we would get this. So that's another net positive for us. Now, the questions, of course, are what's going to happen next, and what is the political buy-in? What is the ownership? There are big questions concerning financing. There are big questions concerning political support. There are, for me, features in the draft statute that, raise real questions, including the lack of a proprio motu authority for the prosecutor. So the prosecutor is not able to initiate investigations on their own behalf. That also creates potential scenarios that I think are not good scenarios. So we are really not at the end of a process at all. We have just moved this. to the next stage.
I had another question, which I will ask, but because you go into these things in the draft statute, that there's no proprio motu definition, just to get clear on that, does that mean that any case would have to be referred as it stands now in the draft statute?
Has to be referred by Ukrainians.
Okay. All right. Good. Then I'm going to move on to kind of some of the follow-up and what will happen now. And one of the elements in that is this International Center for the Prosecution of Aggression that was set up in Europol, and Lithuania is a member. So Gabija, as a member, what is going to happen with that center? Is this going to be like this task force that we had for the Kosovo Tribunal? Is it going to morph into kind of a prosecutor's office, or is it now, are we going to start again from the ground up to build the structure of this tribunal and the prosecution, or will they somehow merge?
So this center, it doesn't have some formal operational or institutional structure. It is being based on the Eurojust system as extraordinary format for cooperation of states. So formally, we all are participating in that center, as it is being called or referred to. We still have our national investigations, and we continue to collect evidence on our national level. What is being foreseen in the statute, that as soon as tribunal becomes operational, national jurisdictions that had the national prosecutions for the crime of aggression against Ukraine, they should hand over the evidence to the tribunal, because as you might know, in this center, there is a common database being established. but still the database does not have ownership over the evidence that is being produced by the countries participating in the center. So that means that still these national jurisdictions, they will have to make formal decision that they suspend the criminal proceedings on the national levels, and they transfer with all the materials being collected to the tribunal being established. But I also, if I may, come back a little bit on this proprio motu, because it ties directly with the jurisdiction issue. I think what from the Lithuanian point of view, what was crucial that Belarus is not being forgotten, so that tribunal has possibility to take into account that Lukashenko's regime is not only complicit in Russia's crime of aggression against Ukraine, but it also committed a crime of aggression while providing its territory. So what was important for us being in the core group, that tribunal has jurisdiction not over the Russian crime of aggression in Ukraine, but against Ukraine, meaning that all the countries that are complicit, that committed separate acts of aggression against Ukraine, they can also be on the table of the tribunal. And I think we can discuss about this, how well proprio motu is being defined, because I think what Christian was referring to, that, does it mean that Ukraine will have specifically to have this criminal investigation on Lukashenko being started as the territorial jurisdiction issue, or the prosecutor of the tribunal having received information, for example, from Lithuanian national jurisdiction, will be able to dip into it and sort of open a separate track on the responsibility of Lukashenko. So there are still things to discuss on this, but for us it is important that it is against Ukraine. There is possibility to open it. And then that we do not have a time limit, meaning that tribunal will have to decide and will have possibility to conclude that already from the 2014, Ukraine is a victim of Russia's aggression. So I think these are also huge achievements, because discussions were not that easy also in the core group concerning these aspects also.
Got a lot of kind of things swirling in my brain out of all of that, Christian. So I mean, this idea of the prosecutor not being so completely able to initiate an investigation, it has to be referred by Ukraine itself. I mean, let's say there's some kind of a peace deal. Does that mean that the prosecutor of a tribunal could be asked by Ukraine to stop doing something? You say it goes back to 2014, Crimea might be on the table then. I mean, again, talking about potential peace deals, what goes on there? And wasn't the US part of your core group? I mean, what was their attitude to all of these discussions going on? Christian?
Look, I agree with Gabija as far as Belarus. It's also something that we have always said nationally in our statements. We don't think it's particularly bold to say that Belarus is a co-aggressor here. And I mean, the law is pretty clear, and that this is open, that is certainly important. Now, the question you're raising, of course, how does this relate to a peace discussion, is something that kept coming up all the time. And, I reminded, not so much in the group, but more in our informal discussions, like the like-minded with Gabija and our other friends, but also internally, I said, look, this is one aspect of a huge file. This is one aspect of the Ukraine file. And for people sitting in this room, this may be the most important aspect, but ultimately it isn't. And I think that's how the Ukrainian leadership looks at it and has to look at it, because that's what you do as a responsible policymaker and political leader. So there is, of course, that dimension that this could become part of a peace negotiation. I mean, very clearly. And given the statute is drafted now, to my understanding, I don't think Ukraine can stop a proceeding, but they can, of course, just not refer things to the tribunal. That is certainly one possible outcome. Now, you may want to talk to Ukraine about this, because they have been very, very keen and emphatic in telling us, both in the room and bilaterally, that, the tribunal is not a bargaining chip. So I'm just quoting them. They said this many times, and I feel safe in saying this here. So this is what they did say in those negotiations, but we're all aware of what the larger political reality is, and that is that everything is on the table once there is, how should I say, a genuine peace process, which we don't have at this point. And whether we will have one, I do not know. But that would typically be, on the table together with issues like compensation, who's going to pay for the damages, in the war, and these huge items and topics. The US was indeed a member of the core group for a long time, but not until the end. So they did at some point pull out of the negotiations, while they stayed longer than maybe some people would have expected or deemed reasonable, but they were still there, but not until the very end. The US had a number of issues they felt very strongly about, and I think you know what they are.
And that's the US, which is now, quite largely not expected to sign this agreement. Are all the other states in the core group expected to sign up? And can you explain how they plan to finance it?
Look, I cannot tell you what other people will do. I think what is fair to say is that there is a slightly strange dynamic in a way, because the people who wanted the tribunal the most, and that's the people that you have in your call, and our friends, the like-minded, they are, a bit less enthusiastic about the outcome now, because we think the compromises were made that we don't find easy to accept. And you had also states in that group who we always felt wanted the tribunal much less than we did, and would also have been okay with not having a tribunal. Whether they now step up and embrace the tribunal wholeheartedly remains to be seen. But I think there is a shift a little bit in, on the skeptical side of states, which includes us, certainly, to that we say, look, we want to look at the positive here, but we also want to see what others are doing. And we certainly want to have an answer to the question of financing, because, there are tribunals that have been financed in a sustainable way. I think it's in particular the Kosovo tribunal. And if you have, in my view, if you have a system of sort of a scale of assessment among the states who ratify this, I do not think that this tribunal is looking at a bright future then, because that's a system of financing that has not worked in the past. So I think we really need to look at this together with, the coordination that we will be having in the ratification process. And of course, last and very much not least, not everybody who is a member of the Council of Europe was in the core group. This is now before the Council of Europe, and there are a number of states who were not in the core group, and they know why they were not a member of the core group. So that's also a relatively open question.
And maybe I can add only on this that I think there is also a challenge, because we understand that we can count financial contribution as soon as we are more or less sure about how many countries would support this. And that is why, to know that the country is able to support it, some of them will have to pass through ratification process. So that means the parliaments are being involved. It's not the case in all the countries, but still some countries will have to have it being, discussed in the parliament. If we take Baltic countries, all the societies had very high expectations for the tribunal. Because we have the history that we have still some feelings of injustice towards, Soviet Union times. And that is why, these expectations not being met to the fullest gives another, argument for the ones, when we have calculations being made. And that is why I think to be so sure that it will be that smooth process sometimes raises, the question how many countries we can count in already now when we do the calculations for the tribunal. But I think overall, as we always say, cross-regional support is of a very important issue here if we talk about legitimacy, and legality of the tribunal. So at least as far as we have political discussions, in the core group, we had not only United States, we had, G7 countries, Canada, Australia, and others. So I think if we manage to get them on board quickly, together with the Council of Europe efforts, because, first we talk about members of the Council of Europe, but then we will have possibility for the other countries from other regions to join via enlarged partial agreement. So if we manage to have this being done smoothly, we manage to get other countries on board, then in next year we might have the tribunal already. But I agree, financial side now becomes extremely important, because now it's even difficult to be precise about it, because we don't know exactly how many states would be in support at this moment.
I don't think anybody can accuse us of being unambitious, because we want to now expand this podcast beyond just the special tribunal for the crime of aggression to do with Ukraine, but also bring in more detail what is going on at the ICC, because we've got you both here and it's a great opportunity to do that. So next month, the International Criminal Court is having a special session in New York, also discussing aggression. So how are we going to tackle it? Should we just have a quick Stephopedia to say what you and I both understand as non-lawyers, Steph?
I'm going to attempt it, but as we already agreed, this probably should be an entirely different pod in itself. And before we started recording, we were also furiously thumbing through our Rome statutes to figure out what we know and what we don't know.
We don't know a lot.
Just to kind of have a like a quick overview, we would have to go back to Kampala and the review conference of the Rome Statute, which established the ICC, which came into, or as we say at Reuters, became a legal reality in 2002 after 60 states signed up to the Rome Statute. But when that happened, the provision on aggression wasn't settled. So in 2010, states met up in Kampala in Uganda, where the aggression was discussed, and the Kampala Amendment was adopted. And since that time, 47 states have signed up to the current regime, which I have always described as that the ICC can currently only prosecute the crime of aggression if committed on the territory of an ICC member state which has signed up to the amendment, and by another ICC member state which has also signed up for the amendment. Now, we had some discussions before whether the Security Council could refer an aggression case if it involved a non-member. And for this, I'm going to go to the father of the Kampala Agreement, Christian, to explain to me what all we got wrong in that very, very broad brushstrokes explanation.
Well, I don't think we should let him in quite yet, because we need to say that this is also a compromise solution, wasn't it, in Kampala, because it was the way that they managed to get the crime of aggression agreed. And it is a very different basis. Anybody who listens to this podcast knows that the basis on which the ICC can prosecute genocide, crimes against humanity and war crimes is different from how it can prosecute the crime of aggression. If we are going to turn to Christian, though, we also ask him that I had understood, if we look ahead to the amendments that might be being discussed in July, then if they are adopted, then how does it get ratified? How does it get agreed? It all seems like quite convoluted. So, Christian, why don't you take it away and run through it from the beginning for us and tell us what we need to know?
Sure. I'll simplify a bit and make it as non-technical as possible. So when we went into Kampala, there were three issues we had to deal with. One is, what is the law? The second is, what is the role of the Security Council, if any, in the application of the law? And three, who does the law apply to? So the first is the definition, which we had talked about in the context of the previous part of the podcast. So that is 8 bis definition that was negotiated over years. It was included in Kampala and enriched by an additional text that is called the understandings, which give more guidance to the judges in applying the definition. But that was the first basket. That was kind of agreed before Kampala. But then, the US delegation joined in Kampala, not having been with us the 6 years before. And so that changed the dynamic, of course, a little bit. And that's also why we added the understanding. The second basket is very important. That's something that people don't talk about it that much anymore. And that is, what is the role of the Security Council in all of this? Most states felt it was important to safeguard the judicial independence of the court. So we should not have a system under which a determination by the Security Council that aggression had been committed was required for the court to exercise jurisdiction. There were a number of states, and unsurprisingly, perhaps the permanent members of the Security Council who did not agree with that. And they said, under the Charter of the United Nations, the Security Council does have the competence to determine what an act of aggression is. Thus, that should be the prerequisite for exercise of jurisdiction. The outcome on this was different. The Security Council does have the primary authority to make that determination, but absent of such a determination by the Security Council, the court can still proceed on the basis of a decision of the judges. So the judicial independence of the court was safeguarded, which, for me was really a absolutely key and essential outcome of Kampala. And the third was, who does the law apply to? There we had a dynamic where a number of states, including the US, said this law cannot apply to states who are not parties to the Rome Statute, a position that the US has taken actually with respect to other crimes as well. But in Kampala, it was deemed pretty early on impossible to get the agreement without making this concession. And of course, that is a huge concession. And it's the concession that forced us to the table to negotiate the special tribunal on Ukraine. Because if that concession had not been made in Kampala, Ukraine, could have said, okay, we are accepting the Rome Statute, we are accepting Kampala amendments, aggression has been committed against us. This goes to the ICC, which is what everybody who cares for international justice thought would be the best possible outcome, but it was legally not possible because of the compromise that we made in Kampala. As a result...
Sorry, I'm going to just jump in and say the compromise you made, if I put it in very simple journalist terms, is that you could only prosecute aggression if it was committed by an ICC member who signed up to the amendment against another ICC member who also has to sign up to the amendment. That is the very narrow jurisdiction, or not?
I mean, not exactly in my view. The main point is clearly there is no jurisdiction of this court over nationals of non-state parties who may have committed the crime of aggression. As a result, then, there was a secondary discussion that states said, well, if it doesn't apply to these people, why would it apply to me? And then we had the opt-out clause, and then we had the activation decision in 2017, which added yet another twist. I don't think we need to go into this. I think the legal reality today is you have a jurisdictional regime of the ICC over the crime of aggression that is extremely restrictive and is very far from the jurisdictional regime that the court has over the other three crimes. So the effort in July is to, as we always say, harmonize the jurisdiction, to make sure that the court has the same level of jurisdiction over all four crimes, which were all included in Rome and were all deemed to be equally important. And there is no legal reason for there to be a differentiated jurisdictional regime. And B, of course, if you look at what is going on in the world, what the conversation is in international relations about the use of force, it's actually very, very important that this change is made.
Gabija, I know you can't speak on behalf of all states. You're representing Lithuania only, but maybe you can kind of channel a bit of some of the like-minded states. Is the issue one of the criticism of double standards, or is it a practical issue? What do you think would be achieved by changing how aggression is dealt with at the ICC?
I think it's about better, in general, protection of the states, accepting Kampala amendments, first of all, because we have 47 states saying that we want the court to prosecute this crime, and we trust the court to do that. And we do not believe that we have this protection and support the court in relation to other crimes being committed on our territory, it is fundamentally and it is crucial to have the same possibility for the court to act in the face of a crime of aggression, because I think what Christian has said, that this is the time to do it, because the aggression against Ukraine proved that the compromise that was made in Kampala, despite the fact that achievement of Kampala is already a huge achievement it has to be amended. And because these ad hoc solutions that we discussed with you before, they are never perfect. And we have a perfect mechanism that is already established. So, and it was established to avoid these ad hoc, mingling around or working, on different diplomatic efforts and levels to find the solution. So we have the solution. And we understand what went wrong in Kampala. So I think that this is the time to be able to admit it and to amend these mistakes, because we understand that if we do not amend it, then we have to invest this huge political, diplomatic efforts in making sure that, as I said, that this crime, safeguarding peace does not stay on the paper. And then we already have 47 states saying that the court must prosecute. So we have also to respect these states and to make sure that the territories are being protected on the same level as they are protected from the other crimes. Because what Christian always says, that international law is fundamental protection that little states such as Ukraine, Liechtenstein, or Lithuania has. So that is why I think, despite the fact that procedurally it will be a challenge, technically it's also difficult to find the only and best solution to make sure that we do not open definition as such, because, there is a discussion there. I mean, how do we approach towards this amendment? Is it amendment of the Rome Statute, Article 5 to be, or is it amendment of the Kampala Amendment? And I mean, for non-lawyers, I mean, it might be quite a simple discussion, but technically it is not. And because if you open, because already in Rome you had crime of aggression there, I mean, but only in Kampala you had the definition that tied directly with the jurisdiction. So there are many, many issues. I think the biggest challenge diplomatically and politically is how to make sure that states are able to meet all the challenges in this session in New York, because what sometimes seems quite a simple legal exercise to be for lawyers is not the case, for the people coming as representatives from states. So I think all the work that is being done now before New York is very, very important, so that procedurally everybody understands it the way it should be understood. Understanding also what led to this compromises that we have also from Kampala.
Christian, Gabija already talked about some of the sticking points and the things that might be difficult. Do you also see these same sticking points, and how do you think it will go? You are kind of a veteran of these negotiations. I assume you kind of know the field in a way. On the other hand, there's been a lot of upheaval just generally in international law and in international relations with these invasions and things that we didn't think we would maybe possibly see in Europe, that maybe fans the flames for, a review of this crime of aggression. It might also work backwards. There's all these powers in play. How do you think it will go, and what the main sticking points would be?
Well, look, this is clearly a difficult decision, because it's an extremely meaningful decision and it's a very important decision. And these things are never easy. As Gabija has said, if you're a small state, this law is, for some states, that is the law that can protect your existence and your sovereignty and your independence. In Rome, a lot of people said, states committing aggression against other states is something that no longer happens. that may have been the case when the UN was created. And a lot of people felt that way. And sadly, today, we know how wrong that view was, because the discussion has moved in the other direction. So now we're seeing things and statements and policies that you would think kind of predate the creation of the United Nations. And the United Nations is created on the premise that the illegal use of force is prohibited and that there is a collective response against the illegal use of force. I mean, the UN is an organization that is created to prevent war, and especially that kind of war. So this is the law that ties the task, the mandate of this court to the core of the international order that we have, which is reflected in the Charter of the United Nations. So in some ways, it's easy to argue this, in fact, is the most important crime. And I think it is the most important crime. And sadly, I think a lot of small states are waking up to the reality that this is the most important crime. And this is why we are now seeing a very positive dynamic around this. This is why, of course, I'm confident, as it is my job to be, that we can get this done in July, but really to make it very clear and plain that this is an extremely difficult decision to take, and that we have a lot of work to do to get it done in July. But the moment is certainly right, and I think we have really been able to create a very good momentum around this conversation.
Interrupting our regular programming just to say, please come and support us on Patreon and get our newsletter. For the price of just a cup of coffee, you can hear Janet and me talk even more about war crimes and books that we like to read and music that we like to read and what we are doing. Come and follow us and support the show. Thank you.
We would like to wrap up for now, reserving the right maybe to come back to both of you if you have time after July, and maybe as we go into the discussions on the special tribunal to be able to ask you some more, because otherwise it just makes the podcast too unwieldy. We always wrap up with a few special questions. Just the first one to either or to both of you. Is there something that you wanted to say that you didn't get the chance to say yet?
Don't ask diplomats and politicians that. This podcast will never end.
I think at the end of the day, you have to adjust your numbers again. There may be 48 ratifications. If the information that we have is accurate. No, I don't think I was unable to say anything. I think you know my view on the special tribunal. We are in the midst of a process, and we will continue investing in this. Unclear for, in my view, at this point where this is going, but we will certainly emphasize the positive while not stop flagging what we think are the flaws in this statute. But more importantly for me, certainly to say, if we can get this done in July, we will never have to have a discussion like this, like the creation of a special tribunal. And I think Gabija made a very important point in saying, people in Rome also said we need this court so we can stop creating these ad hoc courts that are extremely difficult to establish and sometimes even more difficult to finance and to maintain. So this really needs to go to the ICC, which is the central institution that we have given ourselves to defend the international law.
Now, and I will add on it a little bit, because I think it was in the questions that Janet shared with us that is really what Ukraine needs. I think we all agree here that Ukraine, first of all, needs victory. And then, of course, with that, justice is always what Ukraine needs. And tribunal in general for Ukraine is fundamental support that all of us can give in adding, to the military and all the political support, because, sometimes also in discussions, what Christian mentioned, that people say that it is like a bargaining chip. Ukrainians say that it is not. And I think we should stop speaking about justice as being on the way, to peace. It is never on the way, because it is the only way, to deter the aggressors that we have today and the ones that we will have tomorrow. As Christian was saying, that people believed in Rome that it will never happen, but now we live in a totally new reality. And this reality, demands very brave decisions from us, be it special tribunal, be it a review conference in July. So we have only to find a good synergy and to find good unity to make it happen, being small but still very strong in the field of international law.
Our other asymmetrical haircuts question is now maybe a new one if you were on the podcast a lot earlier, probably for you, Christian. But we now ask, do you have a favorite court case, one that you refer to or one that tied into some of the work you're doing or the one that you like to talk about?
No, I wouldn't say. I mean, of course, the court cases before the ICC that deal with questions of immunities are court cases that we like to talk about. So that's the al-Bashir case in particular, yes.
Okay, well, we'll put links to those cases in our show notes. And Gabija, you're trained as a lawyer, so I'm sure you may have had some...
She even has to teach it to students, and so she has a number of cases, I'm sure, that are always at her fingertips.
No, but the one I use very often with my students is the Lotus case in the Court of Justice, because it always inspires creativity, because it's said that everything that does not have prohibition in international law is the space for acting, and being brave. I mean, it was not, this is my interpretation, but they said that if states do not have prohibition, that means they can act on this. So this is what I say to my students.
And our final question, Gabija, is what are you reading at the moment or listening to or watching that you would like to recommend to people? It can be in the field or it can be something you're relaxing with.
Now I'm reading now on the rules of power, and it inspires me because it allows me to understand people better.
Is that a particular book you're reading?
Yes, this is particular book. I think it is 48 Rules of Power or something, with specific episodes from the state practice, and it is incredibly interesting to read.
Christian, is there anything that you read that isn't work or aggression related? That sounds really bad, actually. I was also like, I could call him Mr. Aggression, but that is also makes you look very bad. So let's not do that.
I'm actually reading a book that's called Homegoing by Yagiazia. I hope I don't butcher her name. It's a novel about Ghana and about the history of and the impact of slavery in Ghana. It's a very moving book, and that I can highly recommend.
Great. We'll put links to both of those in the show notes. Thank you both so much for giving us so much of your time, and we will finish it off there. Thank you very much.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.